Right now, somewhere between 700,000 and 1.2 million Indian-born professionals are waiting for an employment-based green card in the United States. Some of them filed their I-140 in 2015, some filed in 2012, some filed before their current employer even existed as a company, and every single month they open the visa bulletin, scan the EB2 and EB3 India cutoff dates, do the math, and arrive at the same answer. Still not their turn. But here is what nobody is telling those people clearly. Waiting is not neutral. The decisions you make, and the mistakes you unknowingly make, while you are waiting directly determine whether your green card comes faster or slower, whether your case survives a job change, a layoff, or a company acquisition, and whether the years you have already invested count for anything when your priority date finally becomes current. Most people in the backlog are in passive mode. They filed, they got their I-140 approved, and now they are waiting for a number on a government chart to move. That is understandable. But passive mode has a cost, and today I am going to show you exactly what that cost looks like, who is most at risk of paying it, and the specific things you need to be doing right now, while you wait, to make sure the green card you have been building toward for years does not slip away because of something that was entirely preventable. My name is Nathan Reddy. I cover U.S. immigration news, policy changes, and green card strategy for skilled professionals. If this is your first time here, subscribe and turn on the bell. USCIS policy moves fast, and most people find out about changes after the window to act has already closed. Let's get into it. First, let's establish what is actually happening in the backlog, because the official numbers do not tell the full story. The State Department publishes the Visa Bulletin every month. It shows cutoff dates for each employment-based category and each country of birth. If your priority date is earlier than the cutoff date listed for your category and country, you are eligible to move forward. If it is not, you wait. For EB2 India and EB3 India, those cutoff dates have been moving in months and sometimes weeks per year on a backlog that stretches decades. The CATO Institute published an analysis showing that under current annual green card quotas, an Indian-born professional who entered the EB2 backlog in 2026 could wait an estimated 50 to 100 years for their priority date to become current. Read that again, not 5 years. Not 10 years, 50 to 100 years under the current system, unless something changes legislatively. That is the macro picture, and I am not telling you that to discourage you. I am telling you that because understanding the scale of the problem is what makes the next part of this video so important. Because within that backlog, there are people moving faster than others, not because they got lucky, because they understood the rules well enough to use them. Point 1. Your I-140 approval is not your green card protection. Your I-140 survival is. This is the single most misunderstood concept in long-term backlog strategy, and it catches people completely off guard when something goes wrong. When your employer files an I-140 on your behalf and USCIS approves it, most people treat that as a done deal. The petition is approved, the priority date is locked, now we wait. That thinking is partially right and dangerously incomplete. Here is what most people do not know. An approved I-140 can be revoked. If your employer withdraws the petition because you left the company, because the company was acquired, because the company underwent a restructuring and decided to withdraw sponsorship, USCIS can revoke your I-140 approval. And if that I-140 is revoked, your priority date goes with it. There is one major protection against this. If your I-140 has been approved for 180 days or more, it cannot be revoked solely because your employer withdraws it. That 180-day mark is one of the most important dates in your entire green card journey, and a significant number of people in the backlog do not know it exists. If your I-140 was approved less than 180 days ago, your priority date is vulnerable right now. A layoff, a company sale, or a change in your employer's immigration policy could eliminate years of waiting in a single letter from USCIS. Action step: log into your USCIS online account or check your approval notice and confirm your I-140 approval date. If you are approaching or past the 180-day mark, that protection is active. If you are not there yet, this is the most important number on your calendar right now. Point 2. The AC-21 portability rule is the most powerful tool in the backlog, and most people are using it wrong. AC-21, the American Competitiveness in the 21st Century Act, allows you to change employers or job roles while your green card application is pending without losing your priority date, provided specific conditions are met. Here is where people get into trouble. They hear you can change jobs after 180 days, and they treat that as the complete rule. It is not. The full rule requires 3 things. Your I-485 must have been pending for at least 180 days. Your I-140 must have been approved before you port. And the new job must be in the same or a similar occupational classification as the job described in your original green card petition. That third condition is where cases fall apart. A software engineer who moves into a pure management role without any technical component may no longer qualify as same or similar under the standard occupational classification codes USCIS uses. A data scientist who transitions to a product management position faces the same risk. The job titles do not have to be identical, but the core duties need to align closely enough that USCIS agrees they fall within the same SOC category. If you are planning a job change and you are in the middle of a pending I-485, get a written AC-21 portability analysis from an immigration attorney before you accept the offer, not after, before. Because once you have ported and USCIS issues a request for evidence questioning your occupational classification, the burden is entirely on you to prove the jobs are similar. And that is a much harder position to argue from than if you had documented the analysis up front. Point 3. The priority date you have may not be the earliest priority date you are entitled to. This one surprises people every time I bring it up. If you have changed employers at any point during your backlog journey, there is a possibility you have an older priority date sitting on a previous I-140 that you are entitled to recapture. USCIS policy allows you to retain the priority date from any previously approved I-140, even if that petition was later withdrawn by a previous employer, as long as the withdrawal was not due to fraud or misrepresentation. The mechanism for recapturing that earlier date requires your new employer to file a new I-140 and then request the earlier priority date in writing. USCIS will not do this automatically. It will not flag your account and say your previous employer filed an I-140 in 2014 and you are entitled to use that date. You have to know to ask. If you have worked for more than one U.S. employer over the course of your career and each one filed an I-140 on your behalf, go back through your records, find the approval notices, identify the earliest approved I-140 you have, then speak with your current employer's immigration attorney about whether a priority date recapture request makes sense for your situation. For someone whose earliest I-140 is 3 or 4 years older than their current one, this is potentially years of waiting recovered in a single filing. Point 4. If you are past your 5th year on H-1B, your extension strategy matters more than most people realize. The standard H-1B is a 6-year maximum. After 3 years plus a 3-year extension, you need a new basis to stay in H-1B status. For most people in the EB backlog, that basis is either an approved I-140 combined with proof that a visa number is not immediately available, or a pending I-485 that has been pending for more than 365 days. The first path, approved I-140 plus visa unavailability, allows unlimited 1-year or 3-year H-1B extensions depending on how far along your case is. The 3-year extension requires either an approved I-140 that has been approved for at least 365 days with your priority date more than 365 days from becoming current, or a pending I-485 that has been pending more than 365 days. Here is what catches people. The 3-year extension is not automatic. Your employer has to file for it correctly and document the basis properly. If your employer's HR team or outside counsel files for a 1-year extension when you actually qualify for a 3-year extension, you will spend the next year going through the same filing process again, same cost, same anxiety, same disruption to your work authorization. Always confirm with your immigration attorney which extension length you qualify for before the petition is filed. The bottom line: if you have been waiting more than 5 years, you are not powerless, but you are not protected by default either. Your I-140 survival past 180 days is your foundation. Your AC-21 portability analysis before any job change is your insurance. Your priority date recapture review, if you have had multiple employers, is potentially your biggest single time saver. And your H-1B extension strategy directly determines how smoothly the years between now and your approval date actually go. None of these things happen automatically. USCIS does not audit your case and flag opportunities. Your employer's HR team almost certainly does not know the AC-21 occupational classification risk. And the priority date sitting on a 2013 I-140 from your first U.S. employer is not going to recapture itself. The green card system is not designed to maximize your outcome. It processes what you file. The people who get through the backlog without losing years to preventable errors are the ones who understood the rules well enough to stay ahead of them. You now know what to look for. If this video gave you one thing you did not know before, share it with someone you know who is in the backlog. They have almost certainly never heard at least one of the 4 points we covered today. And subscribe with the bell on because the Visa Bulletin moves every single month and I will be breaking down every significant shift as it happens. I will see you in the next one.